Morning, everybody. Well, that was weak. Let's try that again. Come on. Good morning, everybody.
Good morning.
Oh, fantastic. All right. Welcome to the Public Safety Committee. It is Friday at 8:30 on September 16th, and I am a committee of one as we stand, and waiting for my other colleagues, Councilmember Jan Perry, Councilmember Ed Reyes, Councilmember Paul Krikorian, and Councilmember Dennis P. Zine. If we could first go through any public comment. Do we have any public cards?
No, sir.
All right. Hearing none, then their public comment is now closed, and we'll go through then the consent agenda. You know, I'll hold the consent agenda so we can at least get another member or two here. So why don't we go ahead and hear the first item?
John White, City Clerk, good morning. Item 1, Fire Department report relative to the voluntary issuance of identification cards after termination and or retirement in lieu of a process to close out personnel investigation subsequent to retirement and or separation from the department, and use of a deposition or court testimony as part of a personnel complaint investigation when the employee fails to cooperate pursuant to motion. Parks Koretz.
Is there somebody from the departments that could respond to that and where we're at? Please.
Good morning, Honorable Chair and
morning.
Absent council members. Trevor Richmond, Planning Section Commander.
I was drinking.
Battalion Chief. Yes. Our report will be brief. I'll just give you a summary if that's okay with you.
Please.
In 2009, there was a motion put forward by the Personnel and Public Safety Committees requesting the fire department answer a few questions with regard to how we distributed identification cards to members after they retired from the fire department. Specifically, the motion asked us to look at what was the process for the voluntary issuance of identification cards after termination and or in retirement in lieu of, and secondly, a process to close out personnel investigations subsequent to retirement and or separation from the department. And then lastly, the use or deposition of court testimony as part of a personnel complaint investigation when the employee fails to cooperate. And in summary of our response, the department does have a process in place. Currently, right now, when a member retires from the fire department, before that identification card is issued, they will be referred to our Professional Standards Division for any current investigations that are taking place. The Professional Standards Division will determine the extent of the disciplinary allegations and then make a recommendation to the fire chief on whether to approve or disapprove the issuance of that identification card.
Okay, let me just ask you a question. Why do we have identification cards for retirees? Is this a similar practice with police department?
Yes.
I know the police department has the retired badges. We also have retired identification cards?
Yes, we actually look for the answer to that question, and the best that we can figure right now is this is past practice with the fire department, very similar, like you stated, Councilmember, to the LAPD.
So the answer is blowing in the wind. All right, so we don't know yet.
Yes, sir.
Okay.
And we are looking at other ways to memorialize their service to the city and not necessarily issue a identification card. We're looking at other options.
And it says retired, I assume, on
Yes,
the
it does.
front face of that card? Okay. Well, not looking to change that then until we get some answers. But the question then is really on the loss of jurisdiction to impose punitive action. And so in looking in that and retired or resign or otherwise separated from their position, it says, according to the report, that we actually lose jurisdiction. And how often does that come to that level? How many investigations are there that are pending that where we'll lose those types of jurisdiction efforts, and at what level? If it's a felony type investigation, if it's a misdemeanor type investigation, does that continue in that authority transfer to somebody else, or do we just lose total jurisdiction over that and close the case?
I will defer to our chief lead investigator, Paul Hayashida.
Thank you. Paul Hayashida, Chief Special Investigator, Professional Standards Division. To answer your question, what we have jurisdiction over is an administrative investigation to impose disciplinary action, i.e. a suspension, send them to board of rights, or whatever else. Often, if the matter is serious, we'll have notified the appropriate law enforcement jurisdiction so that they can begin their own concurrent criminal investigation. The fact that a member either resigns or retires leaves us in a position where we cannot impose discipline on a person who's no longer a member. But we
So if
do.
they're not on the payroll, you can't give them time off without pay, is what you're
Yes,
saying?
sir, that's correct. But we do continue to provide support to the law enforcement agency that's conducting their investigation.
So that investigation, if it reaches that level, if it's a serious investigation, criminal investigation or otherwise, it will continue with another authority? what you suggested.
Yes, with that criminal agency.
Okay, and then in the language, though, it does say here, may, it's my only other concern, may consider whether the member's action gives rise to additional allegations of insubordination, provided the member has been given a lawful order by the proper authority figure. May consider. And so that seems loose. Under who makes that determination?
And that is as towards the third item, which talks about their failure to cooperate while they're still a member. We have found that there may be a number of reasons why on its face someone refuses to cooperate. And so the Professional Standards Division looks at the reason why that failure to cooperate had occurred. If it's clearly insubordination, i.e. the member is given an order and they intentionally disobeyed that order, we will proceed with a new case involving that insubordination. However, sometimes we find that there are medical reasons, sudden emergencies or whatever else that cause the failure to cooperate. And so therefore we analyze the background of what may be a failure to cooperate on its face to make sure that we're not acting inappropriately by charging them with insubordination.
Okay.
So that's why that wording is such.
Okay, because it continues the wording in the report that says PSD often reaches out to the Chief of Staff, Risk Management, and/or the City Attorney's Office before making a closure recommendation to the Fire Chief. And instead of not always, there's often reaches, I don't know what often means.
And that wording is there because
I mean, I know what often means, but it's...
that wording is there because we may have a very minor complaint, I misplaced the nozzle or something like that, on a member who retires. And there's no other reason for us to believe that it's related to some compelling department interest, such as there's a criminal case or there's civil litigation or it's related to hazing or harassment or something like that. And so we will make that decision on our own to close it out without talking with anybody else. Conversely, if there are major other issues involved with it, we'll reach out to the entities that are listed here and have a discussion about whether it's necessary for us to continue our investigation to further their individual needs or agendas. And more times than not, if there is even a hint that there is something else, some other interest at stake, we will continue our investigation. But that decision is made by the Professional Standards Division.
Okay. And I'll go ahead and move the note and file the report. I appreciate coming here this morning. And
Thank you.
Pat. We'll go ahead and move the consent calendar then, and if another member comes, we'll ask for them to back that up. And so on consent, we'll go with 2, 3, and 4, 6, 7, 10, and 11. Hearing no opposition from any of my colleagues, we'll go ahead and do that.
The next item on the agenda is item 5. Board of Police Commissioners and CA reports relative to the fiscal year 2011-12 Real Estate Fraud Prosecution Program Grant Award in the amount of $582,010 from the County of Los Angeles for use by the Police Department for the period of July 1st, 2011 to June 30th, 2012.
Fantastic. Thank you very much. You can state your name and your title and information and let us know what the report is all about.
Ed Rose, Chief Administrative Analyst with the CAO's office. The report before you is a grant award from the county for the 11-12 Real Estate Fraud Prosecution Program, and this allocates $582,010 to the LAPD to fund essentially positions dedicated to the Real Estate Fraud Protection Program that LAPD runs. and it funds 1 police detective and 3 Detective 2 positions within the LAPD. It also provides for related expense and corporate costs. And I have representatives here from LAPD to go into detail if you like.
Well, I have some questions on this, and as real estate fraud, because of the current market conditions, has it gone up or has it gone down?
I'm Captain Bill Williams. I'm the commanding officer of Commercial Crimes Division, which the real estate unit is part of. And real estate crime really has been, we've seen a consistent rise in it, but the issue is what we investigate, because we have such a small contingent of detectives that can deal with this. But for instance, we're doing, 1 year we're doing 125 cases. Now we're up to about 128 open cases that we have with the unit. We have 4 detectives that work with those types of crimes. But we also provide training to our area detectives and also to the community relative to the real estate type issues. I can ask Lieutenant St. Pierre, who oversees our fraud section, to go in a little bit more detail to that, if you'd like some.
Well, I want to know what kinds of fraud we're actually investigating, what we're doing. There was an incident recently in the San Fernando Valley. In fact, it was the 12th District, where we had a squatter who made up a fake lease. And so when it was door knocked, they were able to produce this document. It was a forgery, showing that they were leasing the property when, in fact, he had killed, supposedly, 2 of the renters he was subletting to, also illegally, supposedly, and stuffed them into trash cans. There was a massive manhunt for this individual that ended with an OIS, and I'm not sure if these are the types of things that we're investigating when we have these kinds of leases that are out there. It seems that there are more of these, according to all the news reports lately, because of the vacancy rates, and squatters getting more sophisticated in the fact that they can download any basic lease off the internet or at an Office Depot or Staples and forge the document. So I'm not sure what we're doing in that regard, and I know we're short-staffed. It says here in the report that, and this sentence is rather bizarre, due to a decrease in real estate sales, the funding has been reduced from previous years. However, on the record, you just stated as well that it's, in fact, these types of crimes are going up. Then it further goes on to say in the same sentence, however, there was a $50,000 increase in fiscal year 2010-11 funding, and the LAPD received a 60% increase in the funding for fiscal year 11-12 grant. Just not sure how it says there's a decrease and then it's gone up. But in any event, just what kinds of crimes are we investigating? What are we doing with all of these squatters out there and these fake leases? And is that something you guys are handling?
I'll have him handle that, then I'll talk about the funding.
I just wanted, before you answer that, say thank you to Councilmember Paul Krikorian, who's also joining me.
Good morning.
Good morning.
We investigate basically as part of the grant, any crime that affects title. I'm Lieutenant St. Pierre. I'm the officer in charge of the fraud section, and I oversee the real estate crimes unit. And so anything that affects title, we will investigate, whether it be a change of title or whether it be one where there's false loans taken out against it. Mainly right now, the main emphasis of the crooks, and many of them are very well organized, is they go after houses that have a lot of equity. They'll file false grant deeds, and then they'll turn around and they'll take out loans on them. And a lot of them are going after what we call hard money lenders, investors, not the banks, because the banks have tightened up their rules. But we also do investigate any type of large-scale fraud that involves, such as a loan modification fraud. We have a couple of major cases going on right now involving loan modifications, where these people are being defrauded of millions of dollars, where they're applying to get their houses refinanced under some of the different federal guidelines and federal rules. And there are a lot of crooks out there taking advantage of people who are in desperate needs and in fear of losing their houses. So, but generally speaking, the issue when it comes to squatters, and those are a divisional problem that are handled at the divisional level. And there are a number of problems that officers face when they go to those investigations initially, and I can explain how that works if you would like, sir.
Please, yeah,
All
I'd
right.
like to hear how it does, how it
A
works.
patrol officer gets out there, and many times, all they have is an accusation that there's a squatter there. They don't have an owner of a house there. Person presents a document, and there's no way for that officer initially to prove whether that document is true or false. And with the presentation of the document, and many of these squatters will put things like electricity, power, phone in their name through DWP, which by law, they start to establish residency. And so the officers are very, very much hamstrung on what they can do with these situations. And then there's the issue where there's also a rent scam going on right now that involves organized groups going out. And what they'll do, they'll see an open house for sale. And what they'll do is they'll list that house on Craigslist for maybe the house would normally rent for $1,000. They'll list it for $800. They'll spend $50 at Home Depot, change the locks. People will show up. They'll rent them the house, sometimes to multiple victims, give them a lease, take their first month's their security deposit, and then disappear.
Wow.
And then what happens is, especially for people who own these homes and they live out of the area, so they're not checking on these homes on a regular basis. They'll show up, and a month later, this person's been there. Their kids are registered in school. They've got jobs. Everything, they're living there like they're doing the right thing. And the people are having them send money or MoneyGrams to P.O. boxes, trying to milk them as long as they can. These scam artists. So many times, the detectives in the areas will take a crime report for the owner who's had their house, who's losing money because they can't sell it or they can't rent it themselves, and they'll take a crime report from the victim who may have established residency. And then it's either for them to work out in civil courts or how they work it out without civil courts. It's up to them. So for us, the law enforcement piece, it's very difficult for that first responder to figure out who's telling the truth. Now, if they get them and they're homeless people that throw a mattress in there and that type of stuff, then it's a little different, because it's generally they don't have the leases, or if they have an owner who's staying on top of that property every couple days. They're there 2 or 3 times a week, and they come in, hey, these people just moved in, they don't belong, we can get them out. But these are the problems that the patrol officers face and the area detectives face.
That's just astonishing. Let me ask you, what kinds of tools, or if you had a magic wand, if there's something we can do regulatory, if there's something we could do with, some type of recorded document that would have to be verified to show an officer, that wouldn't be a burden to landlords or renters to obtain. Is there some type of, and I don't know that it's a quick fix, but is there something that we could do to prevent this or make it easier, at least for investigations for officers when they do door knock it and they're looking at a false document, or they're looking at a municipal bill or a DWP bill, utility bill in that person's name that was obtained under false pretenses, or something that you would suggest, or you can go back even perhaps to your detectives and ask them what they would suggest to help them, something we could do as a council to provide some assistance.
I don't have a quick fix at this point. I would have to do that. This is a county-wide and a statewide problem.
Sure.
I know we've looked at, and we're part of a larger county task force where we meet once a month and we talk about these issues. The meeting's coming up in a week. I'll actually bring that up to the meeting, because I think this is a bigger issue than just the city and a way to solve it. I mean, to be quite honest, sir, if I could solve the majority of these things, I would start with the banks, and that would be having everybody who gets a bank account, whether it be online or not, come in and actually give a thumbprint that we could verify. Because so many of these banks, you can open an online account, never actually go into a bank under John Jones, and you're
No offense
stealing.
to John Jones.
No offense to John Jones, but you can then have 6 or 7 of these people depositing money or wire transferring money straight into your account to pay their rent. And we never see them. They draw it out through an ATM, and the pictures we get are poor at best most of the time. And it's a huge, that's the biggest loophole for all financial crimes at this
Well,
point.
and just what it does to a community when you get these kinds of folks into an apartment or single-family residence, and you don't know who's really there, and oftentimes reputable landlords actually do background checks, or they may do at least credit checks. I would assume that these folks who are renting out homes illegally that they don't own or have possession of are not doing that kind of due diligence. And so this is it's shocking to hear that people have gone to this level. So if you could report back, we'll go ahead, and unless my colleagues got any questions, and receive and file the report, or accept the grant, I should say, rather, move to do that. But come back to this committee, if you would, after the county-wide task force, or at least report directly back to me in the office, if you would, on any ideas, suggestions, recommendations, whether it's even supporting a resolution by this council, by the city, to urge the state to take action, and not just take a holistic approach statewide if this is an issue that's affecting other cities and counties as well. And we'll look at doing that as well. And then if my colleagues got any questions to that.
Not so much question, well, one question, but this is an issue that impacts all of our districts, and I know that the chairman probably, as well as I, have heard from constituents a lot about the squatter problem, and it's an issue that obviously has gotten worse in large measure because of the collapse of the real estate market, because of unemployment, because there's so much more opportunity for these sorts of crimes to occur. And I very much appreciate your report about this, because one of the things I've been hearing from people is astonishment that squatters gain rights to stay there. And I think what you've just explained very clearly, and what will be helpful for us to explain to our constituents, is that they don't have rights as squatters, but there's a due process that law enforcement has to go through before they can in fact determine that they are squatters, and that's a very different thing. And I appreciate the chairman's request for us to think creatively about how we can provide you with additional resources, additional information that will make these matters easier to resolve. It seems to me that the principal issue would be having law enforcement have readily identifiable, readily have the most immediate opportunity to contact the true owner of record. And I'm sure that's inhibited in large measure by delays at the county registrar recorder's office, the fact that they often don't have phone numbers or email addresses available for the registrar. Is that at the nub of the problem?
Yes, sir. The delay on any change on a grant deed, if you bought a house for investment, the delay on that change in the grant deed notification is anywhere from 30 to 60 days.
Yes, that's at this day and age, that is ludicrous, it seems to me, that we can't use technology to do that more effectively and quickly and give you an interface that would allow you to verify it on a much more time-efficient basis. But maybe that's something that the county-wide task force can start working toward as well.
Yes, sir. I'll report back to you the meetings in either a week or 2 weeks. After that, I'll report directly back to you, sir.
Appreciate that. Terrific. No, thanks. Keep up the great work.
Thank you, sir.
Thank you. All right. Next item, please.
Next item is item number 8, Board of Police Commissioners report relative to the Ninth Circuit District Court decision, Bryan versus McPherson, and the Police Department's use of force policy pursuant to motion Parks Smith.
I understand that there's staff is not quite here yet to report back on that item, so we'll go ahead and hold that on the table.
Okay. Item 9, City Attorney report and ordinance relative to amending the LA Ad Code to eliminate the title Specialist Reserve Officer and the related monetary stipend.
Morning. Could state your name for the record and...
Craig Heron, the Lieutenant Officer in charge of the Reserve Officer and Volunteer Section for the Los Angeles Police Department.
Okay, and what's the move after all these years to change the title and the stipend for specialists, and where's this coming from?
Well, I'd like to think it was originally a mistake. The name was Specialist Police Reserve Officer originally. And they're not sworn members of the department. They've had no training, so they're not police, they're not officers, and they're not reserves. The name was later changed to Specialist Reserve Officer, but once again, the term reserve and the term officer were incorrect. State agency, peace officer standard training, found some exception with that we were calling officers, these people officers when they're not, and they were calling them reserves. So this is really an alignment to get the language right. It was very confusing to a lot of people that we're calling a group of volunteers peace officers by calling them reserve officers.
Okay. Well, let me just state that, I as a reserve officer who's gone through not the academy once but twice, both as a level 3 and a level 2 in 10 months in the police academy, and going through the background check and the physical agility tests and the oral interviews, going through a polygraph. It would be nice if we had all those requirements for some of the city council members as well, wouldn't you agree? But in any event, present company excluded, of course. I think we want to send the right message in doing something like this, that the message that these specialist reserve officers, even if we're going to be relabeling them volunteers, I consider, quite frankly, not just a clarification, but a promotion. We're identifying them as volunteers. And to volunteer is truly what they're doing is exceptional because they are not getting paid. And certainly they're not doing it for the stipend of $15, which costs the city, quite frankly, more than $15 to process a $15 check, which is another issue we'll get into, I'm sure, at some point, Budget Committee. But in any event, they are truly twice a citizen, and what they do cannot be replaced, not just with the time and commitment they bring, but the expertise in their varied backgrounds, educational backgrounds and experience. We have doctors and lawyers and architects and engineers and all different types of specialists that bring so many things to this department. And I just want to say for the record that in this clarification, the only reason that I support it is because I really truly believe it is a promotion, that we're identifying these volunteers as exactly what they are. I would also ask that we immediately send out an appreciation letter from the department, if I can put in that request, to explain how it is we've come to this name change and clarification, but that it truly is a promotion in recognizing them and their years of service and dedication and saving not only the taxpayers and the residents of Los Angeles tens of millions of dollars over the years in their service, but we want to continue that. We want to embrace that. We want to welcome that and promote it and celebrate it and truly appreciate all of their support. And so I want to put that out there to make sure that the message doesn't come across the wrong way. I think that's absolutely critical. I know that in working with you, LT, and you've been a great supporter of the specialists, of the Reserve Corps. I remember before I went through the academy, I used to go to the CAPS program for 2 years, and I ran with the new recruits, and you were one of my training officers before I was even accepted in the police academy.
I'd like to mention that he's one heck of a runner, so
Yes,
be aware of him.
Just trying to keep up with you, sir. But I really, truly want to celebrate today those specialists and let them know, and if we can put a letter out or communication to them, letting them know that this name change is so we can hold them on a higher pedestal. I would appreciate that.
We've actually done that. We put out a letter that was individually signed, hand-signed by the commanding officer of personnel group, who is the Department Reserve Coordinator, Gloria Gruby, who personally signed each and every one of those, and we sent one individually to every one of them. I'm letting them know so. We also put information on the department website and the Reserve website, letting them know that. They are an extraordinary group of people. This was not certainly anything about their service. I'm not going to mention what you just went through, but you're absolutely right about that. And they're still very much part of our program. We're continuing with the program. We are going through the same backgrounds we always went, which is an enhanced background next to the normal volunteers. These people are truly specialists. They have special skills, and we're still acknowledging that. Their identification card identifies them as such, and they also have entry into some of our buildings that the normal volunteer wouldn't have due to their expertise.
Will their entry into some of the buildings, I know I've had some communication back from some of our volunteers, if you will their identification cards still allow them to enter their local stations where they work?
Yes, if that's deemed necessary by the commanding officer, each of their cards still has the magnetic strip that we can activate remotely. They don't even have to come down to the building to do. I get communication, I tell personnel division to take care of that, and by the next day, they have that electronic access again.
Fantastic. That's good to know. A lot of them didn't get that message, so I'll make sure to share that as well. So I appreciate it. How many total, if you know offhand, and I know you do because you're good, how many total people fall into this pool?
About 300.
300.
300.
300
Yes.
specialists, volunteers throughout the city of Los Angeles, 300 people that volunteer their time after work, on the weekends, during the day, coming in day after day, year after year, for no pay, and they certainly weren't doing it for $15 a month, when and if they actually ever got the check. I know we had problems with that for many, many years, and are answering phones and filing paperwork and working alongside our uniformed officers, and that's, I don't know of another department that has those kind of numbers as volunteers, so that's extraordinary.
We're very fortunate. And that doesn't count the other 600 volunteers we have at the department either that are registered with us. So, extraordinary group of people.
Well, I think that's a testament not only to the department and those people, but to your leadership and the smile you bring to their faces, because I know you're out there working with them every day, so we appreciate that. So I'll go ahead, and if my colleague, Councilmember Paul Krikorian, has any questions on this or statements, and we'll go ahead and move this item. Thank you very much.
Thanks for the kind words as well.
Thank you. All right, next item.
Item number 12, City Attorney report and ordinance relative to authorizing the Department of Animal Services to conduct license hearings even in the absence of a valid dog license, and to establish more definitive barking dog noise and distance criteria.
All right. Let's find out what kind of bite this motion's got. If you would.
Good morning, council members. My name is Dov Lessell. I'm an assistant city attorney. I'm here with Brenda Barnett, who's the general manager of the department, and John Chavez, who's the assistant general manager of the department, to answer any questions you might have.
Well, why don't you just go ahead and, if you could, walk us through where we're at with this, and so we can explain on the record for those who are listening in, for our colleagues who are stuck in traffic and have phoned in and listening in as well, exactly what you're proposing.
There has been a long-standing issue at the department based on the language of the city's municipal code that the department was not able to conduct hearings when there were complaints about excessive dog barking if the dog were either unlicensed or if the license was not valid. For instance, there was a license, but the rabies vaccination was out of sync, and therefore the license was not considered valid. The municipal code language is written in such a way that that following the hearing, action could only be taken against a license. And so there was a question about, well, if there is no license or if the license is not valid, we could not take any action against this license to reissue the license or to impose terms and conditions. As a result, we had numerous complaints about excessive dog barking noises where, because a license was not valid or the license simply did not exist, those could not be brought to hearing and they could not be resolved. In essence, people who had not complied with our licensing laws were being treated much more leniently than those who had in fact complied with the law. We thought that it was high time to try to straighten that out. And that would also include situations where the hearing examiner and the general manager felt that the license needed to be revoked. If there was no license, there was nothing that could be revoked. The language now will allow a hearing examiner and the general manager to take action if there is no license, as if there was a license, and instead of revoking the license, they could order the dog to be removed from the city. If there was no license, they would have the authority to recommend that a license be issued in addition to being reissued. And if the dog owner was to go along with those terms and conditions, the department could issue a new license if there was no license before. This would move all of these barking dog noises ahead and would treat everyone with a dog equally. The other change to this is situations where it creates a restricted dog permit. This is really in situations, it's to give an additional option to the department. There is a lot of authority to issue or reissue a dog license on terms, conditions, and restrictions. There were situations, however, where you would have a dog where the ordinary terms and conditions might not be sufficient, where you had a neighborhood that was up in arms, where the dog may have been a problem, but it was also equally clear that the dog owners would do everything in their power to control their dog so that it is not a problem for the community. Under the existing terms and conditions, oftentimes that was not sufficient, or it was felt that was not sufficient. And the department wanted an additional tool in situations like that, where they knew if they would revoke the dog license, maybe because of its behavior or because of the age of the dog, if that dog went into a shelter, the dog would not be adopted out, and it would be a death sentence for the dog. Coupled with a situation where the owners were really willing to do whatever it took so that that dog was under control. They would build a fence, they would make sure that there was insurance, so that if the dog did get out and create harm, that they would be financially responsible. And so it was felt that by having a restricted dog permit as well, that some of these additional terms and conditions could be imposed to work with dog owners that were clearly willing to do whatever it took to keep their dog, as well as protect the health and safety of the neighborhood. The last item on this is putting more definite guidelines for barking dog cases, so that to try to cut down and to provide clarity for the public as to what would be considered as excessive barking. And so excessive barking would be 10 minutes of continuous barking or 30 minutes of non-continuous barking within a 3-hour period. In addition, the department wanted more clarity and better guidelines on persons complaining about dog barking. So if it was one person complaining, that was sufficient for the department to send out a letter to the dog owner. If that didn't solve the problem and the dog owner, the complainant complained again, what the department wanted was to have at least one additional person not living at that address also complaining about the problem, although retaining the ability in certain circumstances where the department felt that one owner was sufficient to hold a hearing to be able to do that as well, but otherwise to require at least to have two persons complaining about the barking before they would hold a formal hearing.
Okay. So in that, and you've done a lot of work on this, and certainly there's a lot of thought that's gone into this. A few questions. In a revocation, have we ever had a revocation process for a dog license prior?
Yes, there is a revocation process for a dog license.
Currently now, and what's the process of, once we revoke a license, if you will, do we actually take possession of the animal?
The dog owner, there are two types of revocation. One is where the dog is deemed a dangerous or vicious animal, in which case the dog needs to be surrendered to the department and will be euthanized. That's very rarely used.
Right.
We have those maybe once a year, maybe even less than that.
A serious attack,
A serious attack.
mauling?
Yes.
Okay. And then the other cases?
The more usual case is a revocation where it's clear that the dog owner is not controlling the dog, where there's maybe multiple instances of excessive barking, where there's been terms and conditions, the owner has not complied with them, et cetera. In that case, when those licenses are revoked, the owner has a choice. The owner can either turn the dog over to the department or remove the dog from the city of Los Angeles and show the department that, in fact, the dog has been removed from the city and will not be allowed back into the city.
How is that, have we done that? How many cases typically annually do we revoke a dog license under the current practice in those scenarios?
Well, there aren't that many, Brenda Barnett, General Manager, Animal Services, there aren't that many cases actually, because what ends up happening, I mean, in the year that I've been here, when we get to that point, the person will usually file an appeal, and by the time we get back to the appeal, we're months and months into it. But when that does happen, we do follow up, and we find out where the dog has been placed, and we have the name and address where the dog is now living. And we also notify the jurisdiction that the dog is moved to.
Back to the question, though, and I appreciate that. How many cases currently this year, last year, perhaps the previous year, in the last 3 years, have we actually revoked a dog license from an owner and not removed the dog, but had under the first scenario, but under the second scenario, required them to relocate the animal? You say not many, I just want to know, what does that mean? 0?
Less than 6.
Less than 6 in the last 3 years?
Well, less than 2, less than 3 in the last year, I know that.
So we've had some of these enforcement procedures on the books previously. We're looking to make them a little easier in terms of documenting continuous barking, reasonable proximity, tightening up some of the language. But in the past, where we have had the tools for enforcement, they haven't really truly been exercised. That's what I'm trying to figure out.
The bigger problem has been that if the dog is unlicensed, the department felt that it could not take any action at all. And so it would then spend a considerable amount of staff time and energy to try to get the dog licensed before it could then hold a hearing, whether it ended up in revocation or in terms and conditions because of excessive barking.
Then the owner would figure out that if they didn't buy a license, then we couldn't do anything.
So let's assume for a second under a scenario where they have a license and there's continuous barking, and we revoke the dog license.
Okay,
What then happens?
Okay. First off, it's very rare for the dog license to be revoked that first time. So the process the department goes through is, initially there's a letter that goes out warning the dog owner, your dog is, that we've had a complaint about your dog excessively barking, please stop it. I am advised by the department over the last couple of years that usually solves about 3/4 of the problems. For the other 1/4,
Do they read the letter to the dog? I mean, how do they... I'm just trying to figure out how a letter...
These are the smart dogs.
The smart dogs.
The owners and the dog sit down, they read the letter, the dog gets it and stops barking.
Okay.
Either that or else the owner takes the appropriate steps necessary to keep the dog from barking.
And the other thing, sometimes we send an officer out just to talk to the people, and I think they also talk to the dog.
Talk to the dog. We're bringing the dog whisperer. Okay. I'm just trying to follow the reasonable guidelines and how this actually is going to play out in society in the real world. And it sounds like if we've had some process in the past where we really haven't followed it, I'm all for entertaining this new process if it seems reasonable and if it's going to give us more tools in terms of, quality of life and quiet enjoyment for neighbors and making sure that the dogs are actually reading the letter. So how often then, I asked about the enforcement, how often does the department actually throw the cases out? I mean, if we hear a case, we...
I get 4 to 6 cases that come across my desk every week that have been heard, that are varieties of these kind of cases, and I would say that about 4 out of 6 are reissue the license and give the person warning and tell them we have a record now. If this happens again, that there will be more serious consequences. About 2 of them end up with revoking the license or making other recommendations, and then they appeal those quite often.
I think some of the fees here, we should maybe apply them to animal literacy. So, and given the impending the admin program that we're talking about with the city attorney's office, the administration citation program, and I know I've seen somebody from the city attorney's office, quite a few others here that have been working on this. That's a $250 fine, and they wanted to address some of these issues as well, where you're looking at a $100 civil penalty. Why not the $250?
This was something that was worked on, I think, prior to...
That's okay. So then would it be reasonable to say that we should have the same fee structure if that's all moving concurrently at $250? Would it be okay to suggest that this be at $250 as well? Can we amend it to, so they're at least on par?
Mm-hmm. Yes.
Okay. Then I'd make the suggestion that we go ahead and amend it to the $250 instead. And those are all the questions I have. Mr. Krikorian. Okay. So we'll go ahead and move it with those changes. And thank you very much.
Thank you.
Thank you. On item 13, I'd like to recognize that we have Councilmember Paul Koretz in the audience joining us, coming up to the table and gracing us with his presence regarding bath salts.
Item 13, CLA and City Attorney reports an ordinance relative to prohibiting the sale and use of bath salts which contain certain synthetic drugs or their chemical derivatives.
Morning.
Good morning. Thank you, Mr. Chair and colleagues. We all know what bath salts are. They're powdery substances designed to be added to baths, and they're said to improve cleaning and improve the overall bathing experience. In some cases, some of them, like Epsom salts, claim to have medicinal properties. They're everyday products that we can buy at our local department stores, and they're pretty harmless. However, there's a far more dangerous variety of bath salts being sold today. These bath salts can be snorted, eaten, injected into the consumer's body. They're chemicals that are legally bought, sold, and marketed in convenience stores and head shops under names like Vanilla Sky and Ivory Wave. And they're perceived mimics of cocaine, LSD, and methamphetamines, and they're incredibly dangerous. According to Mark Ryan, the director of the Louisiana Poison Control Center, if you take the very worst of LSD and ecstasy with the hallucinogenic delusional type properties of PCP with extreme agitation, superhuman strength, and combativeness, as well as the stimulant properties of cocaine and meth, if you take all the worst of these and put them together, that's what you get. According to the New York Times, some recent incidents included a man in Indiana who climbed a roadside flagpole and jumped into traffic, a man in Pennsylvania who broke into a monastery and stabbed a priest, and a woman in West Virginia who scratched herself to pieces over several days because she thought, due to her hallucinations, that there was something under her skin. Dr. Richard Geller, medical director of the California Poison Control Center in Madera, reports that the synthetic substances contained in bath salts are the most dangerous he's ever seen, and that bath salt users become even more violent than meth users, often with tragic results. Poison control centers across the country are reporting a dramatic increase in the number of calls relating to these bath salts. Last year, according to the American Association of Poison Control Centers, they had 303 calls. This year, as of June, there are already 3,470 calls that have been received, an increase obviously well over 10 times that number halfway through the year. There's been a national cry for federal legislation to regulate these synthetic stimulants. But enacting federal legislation, as we all know, is a slow process. However, after receiving an increasing number of reports from poison control centers, hospitals, and law enforcement, the U.S. DEA has enacted just 10 days ago regulations to make the possession and sale of these bath salts illegal in the United States. On September 7th, the DEA used its emergency scheduling authority to temporarily control 3 synthetic stimulants in order to protect the public from an imminent hazard posed by these dangerous chemicals. However, the ordinance that is in front of you today is broader than the DEA's ban, covers more types of synthetic substances, is permanent, and will go into effect immediately. Our proposed ban is consistent with and will not be preempted by the actions of the DEA, as our city attorney's office will explain, and more importantly, as LAPD Captain Hart will explain in greater detail, it's our understanding that the DEA is encouraging us to go forward with our ban. We must treat this threat not only as a public health issue, but as a public safety issue, to make sure the use of these so-called bath salts in the city doesn't turn into an epidemic, as seems to be occurring across the country. Adopting the draft ordinance in front of you today will allow the council to provide a suitable public safety response while also educating our residents about the emerging menace that these drugs represent. I have Captain William Hart, the commanding officer of the LAPD's Gang and Narcotics Division, here with me today to further explain the DEA's recent ban and also to testify on how important it is for the city to ban these synthetic stimulants. I also have Annie Danino from CLA's office here to discuss the ordinance's urgency clause and the incidence of bath salt exposures locally, and I'm going to mispronounce this name, Brian Sotilla from the city attorney's office to answer any further questions you may have. And I ask for your aye vote and recommend that the council enact this ordinance, which by its urgency clause will go into effect upon the signature of the mayor. And I ask that you send this to council to be heard at its next meeting. Thank you very much for your consideration.
Thank you for that overview as well. Do you have some other input from the panel?
Good morning, councilors. Good morning, everyone. As Councilman Corrett said, my name is Bill Hart. I'm the captain at Gang and Narcotics Division. But I want to point out that I'm not a chemist and I'm not an expert necessarily on bath salts. However, I have been educated a little bit. This first came to my attention last January when I had the opportunity to go back to Washington and attend some presentations put on by the Drug Enforcement Administration back there. And I can tell you, I came back here with the feeling that this is a serious problem, that nationally it's a serious problem, and the DEA is very concerned about it. And that has only been confirmed through some recent conversations with my counterparts in the DEA here in Los Angeles. They are very concerned. They are very eager to work with the LAPD and other local law enforcement in addressing this problem. This is a problem that we probably don't really fully appreciate here. It's primarily started in the southeastern United States, but it's been documented in at least 25 states, including California. As Councilman Corrett said, these are not Epsom salts that you would put in your bath, although that's how they are being marketed. They're really indirectly marketed as legal alternatives to cocaine, methamphetamine, and ecstasy. And the group of people who are typically using these substances are young adults, probably 15 to 24 years of age. They're frequently being used at raves, concerts, parties, social gatherings such as that. I also have some anecdotes, in addition to what Councilman Corrett said, that document the violent behavior that sometimes accompanies this, the use of this. They typically contain methadone or MDPV, which is, if if I pronounce it correctly, it's methylene dioxypyrovalerone. Methephedrone has been banned in the United Kingdom because of several documented cases where people have died ingesting that substance. But both of these substances, they mimic the effects of cocaine and methamphetamine, but in addition to the euphoria that some people feel, these substances cause chest pain, increased blood pressure, rapid heartbeat, agitation, hallucinations, delusions, and extreme paranoia, which has sometimes resulted in violent behavior. In December of 2010, the murder of a deputy sheriff in Mississippi is believed to have possibly been committed by a suspect who was under the influence of bath salts. Another reported side effect is suicidal thoughts and actions, sometimes even 3 or 4 days after the ingestion of these substances and the other effects have worn off. In Mississippi, a man repeatedly slashed his own face several times and then stabbed himself in the stomach with a knife. He was a documented drug user who admitted he had tried every drug from heroin to crack cocaine. He survived this incident, and he said that bath salts caused the most terrifying hallucinations that he had ever experienced. A 21-year-old in Louisiana slit his own throat but missed major arteries and was able to then shoot himself and kill himself. These are right now legally being sold in smoke shops, liquor stores, convenience stores, gas stations, and over the Internet. Internet users have actually developed websites where they will post reviews on how effective or how happy they were with these substances. They've been labeled as not for human consumption, which has been the loophole that's allowed them to avoid being regulated. But as Councilman Corrett says, the DEA has recently enacted will schedule these temporarily as controlled substances. They are very eager, the DEA, very eager for us to enact this ban. It will not interfere with anything that they're proposing to do. And as I said, they're very eager to work with us in trying to address this problem.
Good morning, Annie Janino from the CLA's office. I think Captain Hart really covered a lot of the issues, but I'll just give you a brief overview of some of the incidents we've had here in the city. We've been in contact with the California Poison Control Center, and they've reported that since January they've received 100 calls about exposures to bath salts, the majority of which have resulted in individuals seeking medical attention. In the city of Los Angeles, there's been 6 reported incidents. All 6 of those incidents have also resulted in seeking medical attention. In addition, we've received some reports from some of the rehabilitation centers in the city that people are coming in for exposure to bath salts, so we know that that's an issue in the city of Los Angeles. In addition, we've received reports that some of the head shops in the city and also in the valley have been providing free samples of bath salts, so we know that's also an issue that's of concern. As Councilman Koretz and Captain Hart stated, the DEA has issued an emergency ban. However, we should note that this emergency ban is temporary. It's going to expire after a year, and it's limited to 3 synthetic substances: methadone, MDPV, and methylone. And as Brian Sautelli will explain in more detail on some of the preemption issues, the language of the proposed city ordinance will not be preempted by either a federal ban or the DEA ban, and it's actually consistent with those things. So,
without further ado, good morning, Deputy City Attorney Brian Sautelli. It's nice to appear in front of you, council members, Councilmember Koretz. What the draft ordinance provides, and I'll just give you an overview, is it adds an Article 6.6 to the Public Welfare section of Chapter 4 of the Muni Code. It adds a new provision, 4620, wherein it will prohibit the sale and the use of these bath salts containing these synthetic stimulant type of drugs or their chemical derivatives. In particular, it makes it unlawful to display for sale, sell, give, exchange, or otherwise distribute to any person a bath salt containing methadone, or MDPV. I'm not going to go ahead and pronunciate that long chemical word, but I'll use an acronym which appears in all the literature, or any chemical derivative of methylcathinone, which is also a controlled substance, which is characterized under the Federal Controlled Substance Act. The draft ordinance also prohibits the use or the possession with the intent to use, ingest, inhale, or introduce into the human body any of these bath salts containing these synthetic drugs. It makes it a misdemeanor to do so. In receiving the motion, I had done some preliminary research and talking to the CLA's office and found what a problem this is, not only in the United States, but also in the European community. Many countries have banned these synthetic drugs. They're so dangerous. And in fact, in the United States, many states and many cities have gone forward because there hasn't been any federal legislation to prohibit this type of synthetic drugs. And it wasn't until just last week, September 7th, as Councilmember Koretz said, that the DEA announced a temporary ban of these synthetic drugs due to the inherent danger of these drugs and effects on the human body. And they have that power to do this under the federal law because there's legislation pending in Congress. The federal law provides them with this authority to do a temporary ban for a year, and it could be extended up to 6 months, but it's just a temporary ban. We still don't know whether Congress is going to authorize the law, but I think based on what we've heard today, I think it's moving in that direction. Therefore, it's a definite need for the city to act. Currently in the state of California, we do not ban this. Therefore, looking at what the DEA has proposed and is pending in Congress, there would not be a preemption issue. Under the federal statute 21 U.S.C. 903, it provides that states or cities can act such legislation as long as it's consistent with federal law, as long as it doesn't conflict with it. Therefore, I think the city could go forward in enacting such legislation. After having talked to the California Director of Poison Control in California, Richard Keller, when we were drafting this ordinance, he was, as Councilmember Koretz had pointed out, thought this was as dangerous or even more dangerous as methamphetamine and cocaine because of the effects this has, in cases as he's experienced, had on individuals who congest or injected this material into their body. And what these manufacturers have done, they've done a clever way of trying to market these as saying they're not intended for human use, even though we all know it was intended for human use. And so they get around the Controlled Substance Analog Act. And so that's why there's this federal legislation to characterize them as a controlled substance. And so that's why we drafted in such a way.
Great. Thank you very much. Yes, thank you. Well, thanks for bringing this forward. And it's shocking when you hear that they're selling consumer products on shelves and distributing them with ingredients that could have the same effect as these other drugs that are out there. And so I appreciate that you bring this to our table. I have a couple questions that the labeling, these are, it sounds to me from what I've heard, what I've read, and the proposed language of the ordinance is that these are labeled as bath salts, and they're sold as such. So I'm assuming that the packaging says bath salts on them. Is that correct?
Councilman, they're typically labeled as bath salts. They also could be labeled as plant food. They've been labeled as a number of things other than what they really are.
Okay. Are there other products that have these same ingredients that would be affected as well? Are there any other products out there in the marketplace that have, and it sound, I'm just trying to get my arms around, is it the ingredients themselves or bath salts we're trying to ban?
The ingredients themselves.
Are there other products that contain these ingredients that we're not trying to ban because they are useful, whether they're cleaning chemicals, whether they are other types of things that people typically wouldn't ingest because they're mixed with additional ingredients that would be even more harmful, and so therefore, and they have the warning labels and they have been regulated I'm trying to figure out if we're going to have any unintended consequences by trying to ban one thing and in essence banning several other things that wasn't the intention, and all of a sudden we're citing people for carrying Armor All, for example, or something else that might have one of these ingredients that we didn't realize.
Well, the intended purpose behind enacting the ordinance was to prohibit the sale of bath salts that contain these types of ingredients. There are other types of bath salts which the ordinance would not necessarily make unlawful.
Since these aren't ingested, the bath salts then that are labeled as bath salts, and it says here under the article, proposed language, Article 6.6b, it is unlawful for any person to use or possess with the intent to use, ingest, inhale, or otherwise introduce into the human body any bath salts containing. And then it says under A, it also says to distribute or sell, give or exchange any bath salts. It doesn't say substance containing, it says bath salts. So by simply changing the label, plant food, for example, instead of saying substance containing, it says specifically in this language, any person, any bath salts containing. So it actually have to have a label, I'm assuming, that says bath salts. Otherwise, if it had any other label on it that had these ingredients, it wouldn't be subject to Article 6.6 in the way that I interpret it and read this. Is that correct?
Correct. And that's how the motion came over, is to
I understand that.
institute bath salts. And I think that I'll defer to the department as to what, these various head shops or convenience stores are displaying are bath salts.
So that was my first question.
Right.
So if they're displaying it as bath salts and they take the label off and put it on as something else and call it window cleaner or whatever, or hand cleaner instead of bath salts, or hand lotion or something else, does that then change the enforcement? Does that change the article of in what the intent is, what you're trying to do? Because the language isn't broad enough to just say substance that's contained. And then my question is, are there other substances that do contain? And trying to take the approach of making sure that if we're in fact going after these substances, we should go after all of them. Any product that has these or that contain these substances that are for sale. And I don't know if there are any other products that are useful that have these substances. I'm not familiar, as not being a chemist, what they may or may not be. And so maybe we want to go even further. Maybe we don't. I'm just not sure. And that's why I'm asking these questions, if the research has actually been conducted to look into that. So that was my first question. My second question is on the labeling themselves. Do they actually contain the ingredients, or does it just say bath salts? I haven't seen one of these packages. I don't know if they have the actual ingredients or not. I want to make sure that we don't have police officers writing citations or arresting senior citizens that happen to be carrying bath salts because they didn't know, and there was no ingredients indicating what was in those particular bath salts, because you had indicated earlier in the opening that we weren't trying to ban all bath salts, just the ones that contain these particular ingredients. So do the ones that are being sold in the open market actually have a list of ingredients on the packaging?
I don't know the answer to that, Councilman.
Just common sense. Look, I think the more legitimate bath salts will indicate the ingredients. These, you have to realize, are being sold.
No, and I'm all for common sense, but I think for research, and for rushing this through, and I support it. I'm asking these questions because I support it. I'd like to see us go even further, quite frankly, and that if there's any ingredients at all that contain these substances, where children can get them, where they can be ingested accidentally, where they could be labeled as something other than bath salts, that perhaps they may or may not have the ingredients listed. Are there any other products out there that may have these substances as ingredients that we're unaware of, so we don't have any unintended consequences? These are just some generic questions I'm asking from just reading the language. possession.
Here's
and-
what I would think we could do. I would think we could do, if we find that we're missing some categories in some way, we could do some follow-up legislation to respond to it. But what we're proposing is essentially what's been done across the country. And I'm not aware that so far that anyone's tried to do what they've done with mobile signage in our area, where you say, okay, it's hooked up to cars, the next thing you know, they're hooked up to sleds and bicycles. I don't think we're having that experience across the country yet. So I think we're pretty safe in saying the sale and use of substances marketed as bath salts. So even if it doesn't literally say bath salt on it, if it just says Vanilla Sky, it's pretty easy to differentiate, even if only by its price, because an Epsom salt will be $3 or $4 at a drugstore. These are clearly sold as drugs and are much more expensive. I don't think anyone's had difficulty anywhere else in the country in identifying what the dangerous bath salts are and prohibiting them. And so far, they haven't reemerged as plant food or other categories in massive numbers anywhere else that I'm aware of in the country.
And I think you're right. I think what's going to happen, though, is it's going to be just like the mobile billboards, that if we outlaw bath salts, they're going to end up on shelves tomorrow as something else. And so, at a minimum, what I'd like to do, if I can make the suggestion, is to change in item A and item B, rather than saying any bath salts. We can keep that if you'd like, any bath salts and or any products containing, and just add the language, and or any products containing those substances. So they don't turn around and we spend all the time and effort and energy and come through committee and council and vet all the studies and pass an ordinance and post it for 30 days, and then they turn around and they market it as something else. And so I appreciate that you brought this.
I think that's fine. I wouldn't object to that at all. In fact, I think it's a good idea.
Go ahead.
Although, what I think is if that strategy starts to appear, it'll appear in the places where this has been a more dramatic problem already. Places in the South where they're having hundreds of cases. We're an afterthought trickling into California and some other spots. So we'll be ahead of the game if we do it this way, and maybe we'll be
Let's
an
add
example for other places in the country to avoid the next step. So
And then if I could add, when it comes back to council, if you can report back on what other products may contain, so we don't throw the baby out with the bathwater. There's absolutely no pun intended there whatsoever. But so we don't ban products that we didn't intend to. That we can report back if there are other household items or products that we didn't mean to ban, if we can report back on that. And then I think one last thing is that if people are in possession, that we give instruction publicly on the record on how to dispose of that properly, and that may not go into a trash can. It may have to be sent to a safe center for hazardous collection or whatever that substance might be. We don't want put into a landfill. So I think we need to put that out on the record as well, and then I'll just turn it over to my colleague for any comments or questions.
Thank you, Mr. Chair, and thank you, Mr. Kretz, for bringing this before us, because it never ceases to amaze me, the things that people do to find new ways to abuse mind-altering things.
It is pretty amazing.
As the Chair and I were discussing, who was the first one to think to do this? There's some bath salts. It just amazes me. But that being said, I think I share the Chair's concerns. In fact, I have additional concerns about how we go about addressing this problem. And let me ask the question first. Are there legitimate, widely marketed, nationally known, or nationally marketed brands of bath salts that have these ingredients in them? Or is it only the sort of backdoor, illegitimate head shop kind of faux bath salts that have these?
I believe it's the latter.
Okay.
They're different than the legitimate bath salts.
Councilmember, after talking to Dr. Geller, the California Poison Control, I asked, my first question was, is there any medicinal purpose of these type of chemicals? Is there any value? And he said, absolutely not, that these are, just like you said, a type of chemical used not in the ones that would normally be used for bath salts. He goes, these are the types of drugs, they shouldn't be in there, they have no medicinal purpose, they're just in there so that these kids could get high or get some euphoric purpose.
So the original source of these substances, we can assume to, whatever it is, we can assume to be an illegitimate source with bad intent. This isn't a situation where, like, say, going back to the 50s, airplane glue, where the, harmful ingredient was put in the glue that is then, harmfully ingested, but it's there for a legitimate purpose in glues that are used widely around the country for legitimate reasons. Are you saying that this is a different situation than that, and that the original marketer of these products is doing it with the intent to distribute harmful, faux designer drug chemicals?
According to Dr. Geller, the California Poison Control, that was his position. That's what drew me to this issue as being such a dire need for some legislation in this area to regulate this type of activity, because they're trying to circumvent the Controlled Substance Analog Act.
And I think also just to add to that, in speaking with Dr. Geller and also just reading some other research on this, most of these products, the methadone and the MDPV, these are chemicals that are manufactured mostly by scientists in, I think, India and China, right. And they're basically shipped over. I think a lot of times they're either packaged there or taken to Eastern Europe to package, and then they're brought to the United States. So these aren't chemicals that are even being manufactured for the most part here. They're being manufactured overseas, packaged as bath salts, usually in like little plastic bags, and then sold at, different locations, head shops, convenience stores, wherever these places are. And so these are not, legitimate substances. And the other issue that, came up, which I think is relevant, is a lot of legitimate bath salt, companies are having issues with this, that people are afraid to buy bath salts because they're like, is this the illegal, scary bath salts, or is this, a legitimate bath salt that I can actually use?
And on that point, what I also don't want to see happen is the mom and pop store on the corner who has a shelf full of bath salts, and now the onus is going to, on that shop owner facing potential criminal prosecution, to have to go and check the ingredient level on each one of those bath salts and hope that they were properly labeled by the manufacturer. Unless there's some intent element in this, that these products are being distributed with the intent to, provide for human ingestion or something, you're going to have that situation. You're going to have the problem of, the small business owner, I think, being put into a really difficult position. And unless, as I say, the business model is quite clearly that only bad folks are doing this and there are no legitimate products, then maybe that's something that we can draft to capture that concept. I don't know how you're going to do it. I wish you well in trying to do that. But I without that kind of an intent element, I'm not sure how you avoid the person just saying, well, how would I know what the ingredients were? I'm not a chemist. I didn't test it. If it was labeled, it was improperly labeled, you're going to get all those situations by the distributor, especially because it isn't a controlled substance. So there's no assurance that anybody even actually knows what the ingredients are until they're tested in a lab. So I don't know how we're going to do that in an effective way, but I'd like to see us make sure that we're right about that before we move forward with an ordinance that has criminal background. And again, also, I guess related to that, do we as a city are we empowered to create new restrictions on use or possession with the intent to use of substances that aren't prohibited by the penal code, that aren't controlled substances, that aren't prohibited by federal law?
Well,
I mean, that's a different issue than the preemption issue, I think. Do we have the power to do that?
Well, currently, those substances are now prohibited under federal law because of the temporary ban.
Okay.
Okay. And there's pending congressional legislation
Right,
to make
but
it
if
a
it
permanent
doesn't-
ban.
okay.
So technically, I think we're consistent with the federal legislation. In
That's the
addition-
preemption issue.
There's the preemption issue, which I think we're fine with. Additionally, there's after talking to Dr. Geller, he wanted us to make sure that the ordinance contained a chemical derivative of cathinine, which is a substance currently being as a Schedule I federal prohibition, a sale of cathinine, and that's why he said particularly put the chemical derivative of methacathinine, because that will cover all these, what they call them, designer drugs. They just go around and they try to manufacture another type of drug.
And that's already federally banned?
Correct.
And it's an umbrella under which all these others would be within that category?
Under methacathinine, yes.
Okay.
The other two, methadone and MDPV, are a temporary ban, which technically, under the guise of federal law, are a ban right now. So I think we're consistent with the federal legislation.
Okay. Okay. I'm going to want to see how this plays out and the mechanics of it to understand it better. I mean, it's clearly a serious issue that we want to address. I just want to, as the chair indicated, I want to make sure that as we move forward on this, we're doing this in a way that's going to be constitutional and enforceable and within the authority of the city, and that doesn't unduly impact folks who may not realize that they're in violation of our new law. Thank you.
Okay. Well, it sounds like there are all those questions can we have those questions brought back to council when we bring this back, answered?
Yes.
Both
We can do
questions from Mr. Corey and myself, that would be great.
Do you want
And
to come back to the committee, or do you want to?
I would rather come back to the committee. And we don't have a full committee, and there sounds like there's a lot of questions. I know you're asking for it to be urgent, but this committee does meet every week, so we could bring it back at the next scheduled committee meeting. Do you think that would be sufficient time to get the research done?
It's 2 weeks, right?
That's too, because next week we're on recess.
You think? I mean, I could definitely look into it, and I don't know about Brian.
Yeah, we'll work diligently in trying to answer those questions. I mean, obviously, we're going to have to call outside sources to see what about the products. I know one particular question.
It sounds like there could be, yeah, and with that recommendation, I think coming back to committee might be a better thing. There are a lot of serious questions that are being asked. I want to make sure that there's not any unintended consequences against shop owners, these small business owners, folks that might be in possession of, how we're going to really crack down on these. So I think there's a very, very good intention with these restrictions, but I think we've got to get to answers. There's too many questions on the table for that. So if we can bring that back at the next meeting, that would be great.
Very good.
Okay, with that, I appreciate it. Thank you. Any other closing comments? Thank you.
I would just say, just a couple of thoughts on some of the questions. We are modeling this after states and cities all over the country that are doing exactly the same thing. So we're not breaking new ground. I don't think we're hearing about these as problems. I suspect there are virtually none, if not no, places that sell this stuff that don't know exactly what it is. I think largely because of the price. If you're trying to sell a bath salt, you sell it for $3, $4. If you're trying to sell a designer drug, you sell it for $50. And you know the clientele and you know what they're asking for. I don't think this is in all likelihood going to be a serious problem. The serious problem is the results of these dangerous drugs, and the fact that they're sold to minors and they're given away as samples to people, particularly in L.A., where we're not that experienced with this drug yet, who may not know the symptoms. They know the experiences, but they may not know the health hazards and the danger and the bad experiences that people are having across the country. So I would just encourage that we move this with all due haste so that we don't have many additional cases between the time we put this into the law.
And if I may, Mr. Chair, in the meantime, is LAPD or any other agency of the city doing public outreach, education of some kind to try to get the word out to parents about the dangers of these things and to try to, because I think this is, we may not be breaking new ground in terms of the legislation, but I think it will come as shocking news to lots of people that this is going on. And in the interests of prevention, I think it would be really important to move forward with what this information that you've provided to us today to get that.
I think that's a very good point, because probably 90% of the value of what we're going to be doing is going to be on the education front. And we could start moving on that without waiting for this to pass. We can start preparing materials and an approach to that.
Great. Okay. Well, thank you. We'll come back in 2 weeks with those. I don't anticipate any problems in getting through the committee, but answering those questions I think is critical. And then that also afford you some time, as Mr. Krikorian suggested, in preparing the FAQs, frequently asked questions, to pass out to the community as well for the education process, and putting together perhaps a press conference and letting folks know that this is out there, I think is a very, very good suggestion. So I appreciate that. Thank you. Great idea. Thank you. Thank you. And then all other items, I would move that we go on consent.
Item 8 is a note and file report, I believe?
Yes.
Okay, thank you.
Thank you, Rick.
Thank you.
Meeting adjourned.
Congratulations and bravo for your first one on yourself.
Adjourn.
Oh, yes. Oh, we'll go ahead and, I did in the beginning. And so we'll go ahead and adjourn the meeting. Thank you.